मन विजयी करे मन की शक्ति देना भेद भाव साफ ले सके दूसरों से भूल के हो जो माफ कर सके झूठ से बचे रहे सच कदम बने दूसरों की से पहले खुद को देख करे हमको मन की शक्ति देना.
Thank you, Vaishnavi. I now request our principal, Dr. N. Vanishri, to welcome the gathering.
A very good evening to one and all present here. Our chief guest and the resource person for the day, Dr. K.D. Singh, Director, Law, Competition Commission of India, New Delhi. Sir, we deem it a great pleasure and sorry for the inconvenience and of course beyond our control, sir, the traffic, and a very warm welcome on behalf of the college and the management, sir. A warm welcome to our Chief Executive, Professor K. Suresh, sir. Welcome, sir. And a welcome, hearty welcome to all my dear colleagues, both teaching and non-teaching, and the beloved students who are here. Some of you have finished studying competition law, and some of you are yet to study. A very warm welcome to all of you, and of course the press who are here, and many more to join. And I would deem it a great pleasure to just give a very brief introduction about the resource person. Dr. K.D. Singh, sir, is a legal professional with extensive expertise in competition law and policy, currently serving as the director at the Competition Commission of India. He looks after the work of the Advocacy Division and the Secretariat. He also oversees the IT Division, Social Media Cell, and functions as the Central Public Information Officer of the CCI. Dr. Singh holds a PhD in law from the University of Delhi, where he also completed his LLB and LLM. With a career spanning over 15 years at the CCI, Dr. Singh has played a key role in shaping competition enforcement and policy in India. His previous assignments in the Antitrust Division has also the cases relating to cartels and market abuse are noteworthy, and also his contributions extend to competition advocacy, where he is engaged with diverse stakeholders, including industry and trade associations, consumer groups, academia, and government bodies at both central and the state levels. Dr. Singh has also significant experience in public policy matters, particularly in their interface with competition law, and he has conducted in-depth competition assessments of various policies, statutes, bylaws, and model concession agreements. Before joining CCI in 2010, Dr. Singh was a faculty member at the Campus Law Center, Faculty of Law, University of Delhi, where he taught competition law, corporate laws, international trade for over 5 years. And he's also practiced law before the various courts, tribunals, and the regulatory bodies. He has extensive global exposure as well, having attended and presented at international workshops, conferences, and training programs in institutions such as UNTAD, ICN, ABA, OECD, and the US government. And in 2018, he was on foreign deputation at the Competition Bureau, Canada. And in 2015, he was selected for the prestigious International Visitor Leadership Program hosted by the US Department of the State, and a mentor to numerous researchers and students. Dr. Singh continues to contribute to the development of competition law and policy, fostering legal and regulatory advancements in India. So this was these are his achievements as well. Once again, a warm welcome to you, sir.
Thank you, ma'am. On behalf of everyone present here, I welcome you too. I now request the honor of our resource person, Dr. K.D. Singh, our Chief Executive, Professor K.S. Suresh, and Principal, Dr. N. Vanishri, to inaugurate the symposium by nurturing the plant. Thank you all. I now request our Chief Executive, Professor K.S. Suresh, to felicitate our resource person, Dr. K.D. Singh. Sir, I request you to receive our honors. Thank you, sir. It's now my privilege to invite Dr. K.D. Singh, Director, Competition Commission of India, New Delhi, to deliver his address.
A very warm good afternoon to you all. Professor Suresh, Chief Executive, Professor Vanishri. I am very thankful to the JSS Law College for organizing this advocacy event on a subject which is of great contemporary relevance. It is a new and emerging discipline in corporate law. So as a future budding lawyers, this event will go a long way in not only generating awareness about the competition law and its need and role in the market economy, but as a career also, it is going to give you a new horizon and one more option. This, of course, is a very niche area and is slightly different from other laws. Being an economic law, it is more complex, requires law, economics, and finance, and it is done through professionals in Competition Commission of India. So before I come to my presentation, what is Competition Commission of India is, what is Competition Act is all about, and what is role, and what is utility, and why we should study. I at the outset would like to make one announcement that we have a very robust internship program at Competition Commission of India. Every month, we provide internship opportunities to 15 students from all over India. And it is a paid internship. On the hands-on experience, they are provided by working closely with the officers and various divisions of the commission. I exhort all of you, particularly those who are interested in this branch of law, to please consider doing internship. They can apply on our portal, and CCI being an inclusive organization, as I am also here, it's not that we are only at metro or NLUs or some private or big universities. Everywhere, tier 2, tier 3, we go, and equal opportunity, even those colleges which are not represented in our internship program, we will provide. So we will definitely accommodate your students, and you follow the procedure, get your application forwarded from the principal madam, and then you will get the chance to intern with CCA. And particularly, I must say, during summer vacation and winter vacation, they are peak months. But in the other months, there is not so much of demand. So if you can spare students, it's possible within your rules and regulations. So that will be a good opportunity. So at least in every month, 1 or 2 students can do internship from CCI. They get a good exposure. They can work thereafter with law firms as a research associate with CCI, and many more opportunities will come. So I am putting it in the beginning itself so that you should have some interest and enthusiasm for going through this presentation, and also to consider competition law as a discipline in your studies. With this background, I will take you very quickly about what is Competition Commission of India. So, as you can see, the Competition Commission of India was set up under the Competition Act 2002. So, it is a statutory body. And the background was, earlier we had Monopolies and Restrictive Trade Practices Act 1969. Now, those who are familiar with the economic trajectory of our country, after independence, we followed certain economic model, and initially the focus was on the monopolies itself. But once our economy was opened up, a need was felt that now controlling monopoly may not be a good idea, and we need to allow the industries to grow and to become big. And only when they abuse their dominance or monopoly power, the law should prohibit it. So this is a very fundamental change. If you compare MRTP Act of 1969 and Competition Act 2002, under the Competition Act, the dominance or monopoly per se is not bad. Only the abuse of dominance is bad. So Competition Act was enacted in the year 2002, and it set up CCI, Competition Commission of India. And then there were some challenges to its constitutional validity, and finally we started functioning only from year 2009. So for 7 years we could not, because there were various judicial challenges to the legislation. This law has been amended on 4 occasions, 2007, 9, 17, and very comprehensive amendments which recently took place in the year 2023, and the implementing regulations were notified in the year 2024 only. Now, purely from academic perspective, the difference between Competition Act and the MRTP Act. As I mentioned, Competition Act was enacted after our economy was opened up. It was liberalized. And MRTP was when central government command and control regime was prevailing. Here, everything is defined very clearly under the new law. And importantly, it also provides for mergers and acquisitions. So if any merger or acquisition is taking place in the market, those mergers which are typically very big, because not every merger comes to CCI, those which are big in terms of assets and turnover, they need to obtain prior approval of Competition Commission of India. Only then a merger can take place. We have also the power to impose monetary penalty, which can go very high. And MRTP Commission did not have this power. They only had the power to issue cease and desist order, that you stop doing this act, but they could not impose monetary penalty. And as the student of constitutional law, you are aware, Parliament can make law which has extraterritorial operation. So Competition Act in section 32 clearly provides extraterritorial application of the act. So if an act is taking place outside India and cartel is taking place, say, in Japan, and the goods are exported to India, then we can look into those types of arrangements as well. So even if the conduct is taking place outside India, but the effect is having in Indian markets, then CCI can look into it. So this is a very vast power in terms of monetary penalties, which is in 10% of the revenue, and extraterritorial jurisdiction. Before I come to the technical part, let me tell you why you should know why and how competition is so essential for our economy. Now, before our economy was opened up in the 90s, we were a very closed economy and there were not many players in the market. So even if you go to open a bank account in those days, when there was no competition from the private sector, from the foreign HDFCs, ICICs, and they did not come, the bank accounts can be opened only with the public sector nationalized banks like SBI. So the public sector banks had the monopoly. And it was a very difficult task to open a bank account. Even when I came to study in Delhi and I wanted to open a bank account in SBI, they asked me to fill up a form. And the form had one column that you have to sign it from a person who has a bank account for last 10 years, who will stand as a financial guarantor, and only then they will open. Now, when you have monopoly, you do all type of things. Now, how is it possible for students who go to new place to find a person with a bank account in 10 years? Their seniors will not be staying for 10 years. So how you get this? And what for? You are opening a bank account and you are asking me to give guarantee. I am putting my money, you have to give me guarantee. But they are asking the customer to give guarantee. So when you are lazy, there is monopoly, people have no option. Now today, if you have to open a bank account, you can go to SDFC, ICICI, Kotak, they will give you better rate of interest and they will, in 2 minutes need they will do. No guarantor is required, nothing is required. They will bring papers to your home, sign it, and 5 minutes you go live. This is the beauty of competition. So when there is no competition, there is no choice to the consumers. And now you get better interest rates instead of 3.5 with the government bank. Private banks may perhaps offer you more, faster service. They can deliver services at home. You take the example of aviation. When Air India had the monopoly, air service in up to 90s. Now traveling by air was a very rich luxury. Not everybody could afford it. It was considered a luxury for rich people only. And people used to consult astrologer. And astrologer used to see that, yes, this year you have a chance to fly. Zodiac sign used to be consulted. But today, with multiple players in the aviation sector, airlines industry, many of the students must also have taken flights to their hometowns. And you don't have to travel all the way for 24 hours, 36 hours to go to a place. It is affordable. And it saves your time also. That's also very critical. You take the example of automobile sector also. When there was no competition, what were the automobiles? Ambassador car and Premier Padmini Fiat. But now you have Korean companies, Japanese, French, American, Indian, so much of competition. No two cars on the road has the same make or model. You can see it. Even if I take you more back, because most of you might not correlate, the Bajaj two-wheeler scooter, they used to be very popular. As Professor Suresh, being my contemporary, can vouch. So, scooter, you have to first book, and the delivery date was 10 months, 1 year, because we didn't have the production scale. And Chetak scooter was considered to be the king. So, what they used to do, the daughter's marriage, the date will not be fixed until the date of delivery of the scooter is fixed. So, I can go on and on. You take aviation, banking, insurance, automobile, four-wheeler, two-wheeler, any example you take, you will find once the competition came, the things became better. But now there is a catch. Now let's say there are 4-5 airlines. They are competing, cheaper fare, better services. But one fine day, the CEOs, Professor Suresh being CEO knows, if these CEOs in a room they decide to form a cartel, that why to undercut each other, let's all raise the price together from Mysuru to Chennai by the same 2000 rupees. Let's increase. Then where the consumer will go. So, free market should not be a free pass. Otherwise, once the competitors collude, then there will be no way for the consumers. And similarly, if monopoly, we have said allowed monopolies, as I mentioned, dominance we have allowed. But if a company becomes big, no problem. But after eliminating all the competitors in the market, there is only one player. And he said, now I am the only player or significant player. Now I will charge more and I will put more onerous conditions that if you purchase this, you also have to purchase this. Then also there is a problem. So whether it is a monopoly when there is only one player or when it is an oligopoly, then there are more players. If they collude and if single you are there, you abuse, either way there is a problem. So therefore, free markets, competition, more players, more choices, cheaper prices, but with their own attendant problems of collusion, cartelization, and abuse of dominance and monopoly power. Therefore, we need a market watchdog. And that watchdog is Competition Commission of India. So the Competition Commission of India ensures that there is a free and fair competition in the market. And I will give you various examples during the course of the presentation. How we ensure there is a level playing field and competition is free as well as fair. How do we do that? If there is a cartel, if there is an abuse of dominance, including dominance by digital players, you can go through our orders against Google, the Android phone when you have. So Google owns Android platform. There are so many apps which come pre-installed, all Google apps, YouTube, Maps, Google Drive, so many things, Gmail, which cannot be uninstalled. We have issued an order in that case. So let me now tell you about the structure, composition, our mandate and our powers, and some cases how we ensure free and fair competition, including in digital markets. So it is a statutory body. As you can see, it has been set up under an act of parliament, that is the Competition Act 2002. We have a chairperson and minimum 2 to maximum 6 members. So currently we have 1 chairperson and 3 members. What is the objective, the preamble? So this is our mandate, fourfold, to prevent practices having adverse effect on competition. Now please mark the word adverse effect. Not every practice, because we are pan-India regulator, everything, so many small things, they also affect competition. But that cannot be handled by CCI. Having adverse effect on competition. To promote, now we have to take positive steps. To promote, and that is the prohibitory. Now this is a positive mandate to promote and sustain competition in markets by advising government to bring laws or amend laws or to bring policies which are pro-competitive to protect the interest of consumers. Now consumer is at the heart, no doubt. But it is different from consumer forum. Consumer forum only a dispute between a consumer and the seller. If there is a defect in goods or deficiency in service, then you can go to the consumer court. But if there is a problem in the market as a whole, then you have to approach CCI. So our role is the entire economy centric, not one individual grievance. So consumer part is very much there, but you should not confuse CCI with some sort of consumer forum. That every consumer dispute can be brought before the commission. That is not the appropriate forum. To ensure freedom of trade. So not only we ensure consumer interests, we also ensure that other market participants can also freely do their business. So we basically ensure competitive process. What are the functions of CCI? Section 3, 4, 5, 6. These are our main functions. Now, Section 3, anti-competitive agreements. This is a very crucial provision of the Competition Act. So, Section 3 prohibits anti-competitive agreements. Now, any agreement will require minimum 2 players for an agreement. And this agreement can be a broadly horizontal agreement or a vertical agreement. Now, horizontal agreement is the agreement which is among the players who are in the same business. For example, 5 cement companies, if they enter into an agreement to increase price, or 5 airlines, or tire companies, or sugar companies, or steel companies. So horizontal agreement means agreement among the players who are in the same line of business. What is vertical agreement? Where the agreement is between the producer and the wholesaler, or between wholesaler and retailer, who are at different stages of the production chain, vertical line. So if the wholesaler says to the retailer that you buy product A from me, then you also have to buy product B. Tie-in, exclusive supply, exclusive distribution. These agreements are vertical agreements. So Section 3 of the competition law says you shall not enter into any anti-competitive agreement. And if you enter into any anti-competitive agreement, then such an agreement is void. The question is, which I put to all of you, between these two agreements, horizontal and vertical, which agreement you consider to be more pernicious and more harmful between these two? Horizontal, and those who say vertical? Vertical? Why you feel vertical? Well, both agreements, they have to cause appreciable adverse effect. But horizontal agreements typically are more harmful. The reason being, the competitors are meeting. If 2 competitors are meeting, the great economist Adam Smith said, they are not discussing the weather in Mysore. They are discussing something illegal. Otherwise, why the competitors should meet? Why they will meet? So if the competitors are meeting, if the agreement is between competitors, horizontal agreement, this agreement should cause more concern. And under the law, if the agreement is horizontal, then it shall be presumed to have appreciable adverse effect on competition. But if it is a vertical agreement, then the commission has to prove it has caused appreciable adverse effect. Burden is on us. If it is horizontal, then there is a presumption, statutory presumption. We don't have to do anything. We just have to show these two competitors have entered into an agreement and they did the forbidden thing. We don't have to show that it has caused appreciable adverse effect on competition. That is presumed. You can, of course, rebut it. So this is the anti-competitive agreement, section 3. Here, there are two players, either this level or this level. Second is prohibition of abuse of dominant position. So either you are a monopoly or you are a dominant player, a big player in the market. And if you impose unfair or discriminatory terms, conditions, or prices, then that is abuse of dominant position. And that is also prohibited under the law. Here, there will be only one entity. Abuse of dominant position will require only one, unlike anti-competitive agreements where minimum there will be two entities. Then we have regulation of combinations, which more commonly you call mergers and acquisitions. We use the word combination. So mergers and acquisition means if there are two entities, either they are merging or one entity is acquiring another entity, then depending upon the size of the transaction, the deal value, the assets and turnover involved, they need prior approval of CCA. So this is our second mandate. So first is anti-competitive agreement and abuse of dominant position. I have mentioned the word ex post and ex ante. And as you law student understand these words, abuse of dominant position and anti-competitive agreement prohibition is when the cartel has already taken place. Everything has already done. And we are now investigating and penalizing. It's already done, sort of post-mortem. But in merger and acquisition, since they have to obtain prior approval, it is ex ante. Before anything has happened, the parties are approaching. So that is all I have mentioned. Then we have advisory function. As I indicated, we have to promote and sustain, not just prohibit anti-competitive things in the market, but also take positive steps. Just not punishing the illegal things, but do some positive work. How to do? To advise government. This policy can bring more competition. This law is creating monopoly. Delete, repeal it. So we have to do that through our advisory functions to the government, which is our second mandate. The third mandate is competition advocacy, where we advocate with various stakeholders, academia, like educational institutions, trade associations, industry associations, professional bodies, bar council, chartered accountants, cost accountants, CS, and consumer associations. We have to not only generate awareness, awareness is one part of the advocacy. This event, why I have come from Delhi, I have come as part of our statutory duty under section 49, subsection 3, competition advocacy. So we have to spread awareness also. Of course, competition advocacy is a very large thing. Awareness is the low hanging. Because if you become aware of the law, you opt for law, you become advocate, you assist commission, you assist your clients how to remain compliant with competition law, how to maintain competition compliance program in your organization so that your company, your firm does not violate competition law. So competition compliance is very important part. And awareness, of course, so as a part of our advocacy efforts, we engage with academic institutions. We provide internships. We organize lectures, seminar, talks, conferences, and we also sponsor moot court competitions. And I was just before coming here, I was speaking to your faculty member, Mr. Nair, and he was thinking, and a very good idea, that they also want to conduct a moot court competition on competition. And of course, CCI also sponsors. So I have asked him to discuss the proposal with principal madam and your chief executive. And let's then put a proposal which can thereafter be put before the commission. Because if there is a moot court competition, students will feel encouraged to participate. There are prize money, which of course we will sponsor, and other incidentals also. So these events are very important, and students will take interest. And once they opt for competition law, and there is a good stream of competition lawyers in the economy, that will be a very win-win situation. Because if they can advise their clients how to remain compliant with competition law, it can also reduce the pendency of work at the CCI also. Because then cases will not come to us. You have addressed them beforehand. So it is a very good approach. So these are our functions. The nature of proceedings, the standard of proof. As the law student, you know, there is a civil law, there is a criminal law. In criminal law, the standard of proof is beyond reasonable doubt, because somebody's life and liberty is at stake. And on the civil law, what is the standard of proof? Preponderance of probabilities under CPC. CCI is also a civil law. Competition Act is a civil law. So our standard of proof is also preponderance of probabilities. Our law is applicable both to the government entities as well as private entities, because otherwise it will not be a competition law if you only apply to private sector and not to the. So CCI has investigated government companies and has also penalized them as with very heavy penalties. Now, unlike a civil court or a consumer forum where only an aggrieved consumer can go, if you have bought a mobile phone that is defective, you can go to the consumer forum. But here, if some cartel is happening or some anti-competitive agreement is happening, any person can come, whether he is aggrieved or not aggrieved, he can approach. So a student or any public spirited person, even if he or she is not himself aggrieved, he can approach the commission. He need not have the requirement of proving his locus standi, that he is aggrieved and then he is approaching. Governments can also make a reference, and CCI can take suo motu also. If you read a recent order of the CCI in WhatsApp Meta case, where WhatsApp came out with its privacy update and asked you, forced you to accept the update, the CCI has ruled that this is anti-competitive and impose penalties upon it. Then these things I have already spoken. These are our enforcement functions: anti-competitive agreements, enforce prohibition, prohibition of abuse of dominance, and regulation of mergers. Now, anti-competitive agreements I have already indicated can be horizontal and vertical. Horizontal agreement in the same business, commonly they are known as cartels. So we say cement cartel, steel cartel, sugar cartel. So if the people in the same trade, they agree to limit or control price or otherwise distribution or production, then it is a cartel. Bid rigging is also a form of cartel. Bid rigging is when the government floats a tender and there are 4 participants and they all join hands together, quote very high price. That is bid rigging. So we have a very good role in bid rigging also, but that is in the context of government tenders, because private parties don't invite tenders. They are more efficient, but government has to follow the due process. So they have to give wide publicity and general financial rules and everything we have to follow. Vertical agreements, as I said, they are considered to be less harmful. Sometimes they can be beneficial also. So here, they are not per se bad. There is no presumption of appreciable adverse effect, but we have to show that they have caused appreciable adverse effect on competition. Tie-in arrangement, you buy one product and you are sold one more product. Exclusive supply or distribution agreement, refusal to deal. So, agreement. When we talk about agreement, anti-competitive agreement, it is not the agreement under the law of contract, because that is a valid contract, a lawful contract. There is offer, acceptance, consideration, lawful object. These agreements are illegal. So the formal requirement of contract is not required. It can be in writing or not in writing. And any arrangement, understanding or action, even if by your conduct, your facial expression, you just make some sign that let's agree, wink, nod, everything is an agreement under the competition. Now I am skipping some slides, but I am giving some example how CCI is an important body and has a critical role in the economy. Cement cartel case. So in this case, CCI imposed a penalty of 6,700 crore on cement companies. So that is why CCI is more feared, because it can impose huge penalty, which can go up to 10% of their global turnover. Even if they are operating outside India, it can go up to 10% of the global turnover. So in this case, it was found that cement companies, top cement 10 companies, under their trade association, Cement Manufacturers Association, they increased the price in collusion by forming a cartel, and CCI imposed a total of 6,700 crore penalties on. Abuse of dominance. Who is dominant? Ability to behave independently. You have no option but to go. For example, Coal India Limited. It's a government company, but in coal mining, this is the only company. So it is obviously it is an extreme form of dominance. It is a monopoly. But there can be a situation where, like Google, in search engine, it is dominant, around 80% market share, around 80%. Under the new law, dominance or monopoly or size is not a problem. We also want the industry to grow, become big, because only once they become big, the scales of economies can be reaped and prices can come down, we can become more competitive. But if you abuse your dominant position, then that is prohibited. So dominance per se is not bad, abuse of dominance is bad. Now this is a key lesson, particularly from MRTP if you compare. So these are the instances. What are the abusive conduct? Imposing unfair or discriminatory price. I will give some example. Limiting production of goods or provision of services. Denial of market access. Now this one example I will give you, abuse of dominant position. So DLF is a builder in a New Delhi capital region, in Gurgaon particularly. In the North India, it's a very prominent builder. So the DLF has flat buyer agreement with its buyers. So there are so many builders and they have some agreement with the flat buyers, which is known as flat buyer agreement. So in that agreement, there were conditions which were unfair. one-sided against the consumer. So if you delay the project, the penalty on the DLF is very small. But if you delay your EMI, your installment, then the interest can be very penal. So the obligations were not equal, unfair and discriminatory. So this is a case you can study on your own. I will keep these slides. So what are the views? You can increase the number of floors. So when I bought the flat, you promised me there will be 10 floors and this is the open space. But then you said, no, 10, I will make 10 more. So if 10 more comes, then open space gets less and project becomes more crowded. So these are the unfair conditions. So you put in the flat buyer agreement, the term that builder can increase the number of floors at any time without consulting the buyers. So all these provisions were struck down by CCI. And if there is a delay in completion possession, there is very minor penalty. But if I delay my EMI, you charge penal interest. Now this is something which most of the students can correlate. The abuse of dominant position in digital markets. Now, Android. What is Android? Android is an operating system. Like if for your desktop you have an operating system, Windows. Similarly, for mobile phone, you need an operating system. This is a hardware, but there is also a software. Then only it can work. So in India, most of the smartphones are running on the Android operating system and rest are different, including Apple, which has its own proprietary operating system, that is iOS, which it does not license to other phone makers. It's in-house. But Google has an Android operating system. And Google says it is an open. It's an open. Anybody can use it and make the phone. It's free. Now something which is free, is that free? There is no free lunch. Before coming here, Professor Suresh offered me a very sumptuous lunch. Is that lunch free? He said, now you have to deliver a 2-hour presentation. It's on the lighter side. Now, so Google says, you use my operating system for free. So Samsung can use it, Vivo can use it, Oppo can use it, OnePlus, anybody can use it for free. My only condition is my 9-10 apps, they should come pre-installed on your phone and they should come prominently and you should not be able to uninstall. That's all. That is all my request is. Now you have, what are these 8-9 apps? Gmail, Google Drive, YouTube, Google Maps, Gmail, GPay is not, yes, Google Photos, anything more? Yes, Play Store. That is the gateway from where Google takes commissions from all the app developers. You cannot download any app outside Play Store. So these, it says, so CCI found Google in contravention of Competition Act for various agreements which they executed with smartphone manufacturers. These agreements required phone makers to mandatorily pre-install Google Mobile Suite, these 9-10 apps, which included Google Maps, Gmail, YouTube, etc., with no option to uninstall. Prominent display on the home screen, the very first screen, that was also found to be unfair. So we have imposed a penalty of 1300 or some crores, you can check, and you read it, because digital you are so fond of. So Android is an operating system owned by Google. It is also not developed by Google. It was a different company. It was a merger and acquisition. They acquired, like Meta. Facebook acquired WhatsApp. Facebook acquired Instagram. In digital economy, these acquisitions are known as killer acquisitions, where a big player, if thinks a new law college is coming or a small good institution is coming, they acquire it. You must be aware. So there are more judgments, but I don't want to take more of your time. I will leave this presentation so that you can study. And I want to conclude on this note. And thereafter, I will, of course, be taking some questions or any interaction separately outside also with faculty or students. Here also, no problem. Now, at least I am free. And again, I sincerely apologize that you all had to wait till so late. You have come so early in the morning. You are so patiently waiting to listen to me. I am very thankful for your patience, and my apologies that I could not reach on time due to some reasons which were not entirely within my control. And again, I request, if you want to do internship, we will definitely consider, because we have not received any candidate to my knowledge from your college. So you can come daily, 1 month internship, paid internship, and we will provide you a good exposure and training, which will open a new horizon for you in pursuing competition law as a career. I am also in touch with your administration and the faculty on moot court. If we can agree on that, if not moot court, some other seminar we can have at least once in a year. So something or other we will have, but I will try to consider whether this is feasible moot court competition. And he has assured me that we can pull it off, so we can work out the modalities, and we will be happy to sponsor it financially, and through our resource persons who will come to judge the moot courts also and to help in various other ways. So with these words, I again thank the administration, Professor Suresh, Madam Vanishri, for conceiving this event, which has provided students an opportunity to understand the importance of competition law. And also I thank the faculty and the students for being present and making this event a success. Thank you very much.
Thank you, sir, for sharing your knowledge and expertise with us. The floor is now open for questions.